SJC-12346, Dental Service of Massachusetts, Inc., v. Commissioner of Revenue.
Mr. Kravitz, good morning.
Good morning. Good morning, Mr. Chief Justice, and may it please the Court. Chapter 176I, Section 11, imposes a premium excise on preferred provider arrangements in order to assess the value of the franchise in Massachusetts. And the dispute in this case is how to calculate that assessment. And the heart of the dispute is the term covered person, which is used in Section 11, but which is defined in Section 1 of Chapter 176I. And the definition of covered person in Section 1 is a broad one, and it has two parts. A covered person can be either a policyholder or a person on whose behalf an insurer is required to pay for health care, essentially. And both parts of this definition have to do some work. They can't completely overlap, otherwise we have a surplusage problem in the statute. And so in the context of group insurance, where an entity like an employer or a union, but most commonly I think an employer, negotiates with an insurer, they negotiate rates, they negotiate terms, and there's testimony along this line in the record that that's exactly what happened here. The insurer and the employer come to an agreement, they enter into a group or blanket policy, and then the employer makes coverage available to its employees. In that context, the employer is the policyholder. And we know that from common sense, because again, those are the parties that have entered into the contract. We know it from this court's case law. The Foster and the Kirkpatrick case in particular have repeated.
What about the other parts of the definition where Delta Dental will argue it has to be the entity that receives the health care benefits and the employer doesn't receive health care?
That portion of the definition, we think, the on whose behalf language, we think that modifies the word person, but it does not relate back.
So that relates to dependents?
I beg your pardon?
That relates to dependents?
Well, we think that a person entitled to health care coverage is an individual insured, and it may be the employee, it may be the employee's dependents, it would be any individual who is entitled to coverage under the policy. And so, again, I think the most straightforward reading of the statute, given that this is a group insurance context, and there's no dispute here that is the bulk of Delta Dental's PPA business in Massachusetts, that the policy holder refers to the employer, and then the person entitled to health care coverage, which is the second half of the statute, that refers to all of the individual insureds, the employees and their dependents who are also covered under the policy.
Who's the premium payer?
The premium payer in this context is typically the employer. It would be the group policyholder. And this court...
Do they pay it, or are they just like collecting it and then distributing it to the insurance company?
Well, the typical arrangement is that the employer may take the employee's share via a payroll deduction, but then the employer is the entity that is responsible for remitting the full premium to the insurer. You don't typically have employees writing a monthly check directly to the insurer. And so if covered person may encompass an employer policyholder, then the question is, does it in Section 11? And the answer to that question is yes. The context of Section 11 is, as I said at the outset, an assessment. It is based on the gross premiums received. It's a straight percentage, 2.28% of the gross premiums received by the insurer. And again, as in response to Justice Cipher, it is the policyholder who pays the premiums. So that is the transaction that Section 11 is focusing on, the receipt of the premiums from the policyholder.
Is the insurance policyholder
for the out-of-state employees who live out of state, are they paying a tax at all?
You mean a company that is located out of state?
You've got the company in state, and you got the employee
Correct.
who's working in Massachusetts but lives outside of Massachusetts. Is there a tax being paid there?
Is there a tax being paid by the insurer, by Massachusetts insurer like Delta Dental?
Right.
Well, that is the question in the case.
No. So
I'm sorry, I'm not understanding your
So
question.
you've got employees
Yes,
who live out of state,
correct.
and they are receiving health insurance.
They are receiving health care
And is-
through their.
And is there anybody that's paying a tax on that if they live out of state?
The way Delta Dental has filed in the past,
Yeah.
the Delta Dental pays tax on those premiums for the out-of-state employees because their employer is in Massachusetts.
Yeah.
Now, if we're talking about out-of-state employers, that is a different situation, and it's not one that is presented here, because there's no dispute that all of the contracting parties with Delta Dental are Massachusetts-based employers, even though some large, roughly 50%, according to the evidence at the hearing, roughly 50% are located outside of Massachusetts. So the question in the case is whether Delta Dental must pay the assessment based on the premiums paid on account of those employees, even though the premiums are actually paid by the in-state employer to the insurer, to Delta Dental.
Is there a way to separate out the premiums that share the premium that's paid by the employee, which would be their argument, right? That what's only taxable is the amount of premium paid by the employee, correct?
You're saying only the employee share would be taxable? My understanding is that is not their argument. As I understand their position, they would say that if an employee lives in Massachusetts, then the entire premium is taxable. And if an employee lives outside of Massachusetts, none of the premium is taxable. That's my understanding. Mr. Ryan can correct me if I'm wrong about that.
And if you are right, would there not be a constitutional problem if indeed the person resided in New Hampshire and New Hampshire also taxed that for a New Hampshire resident?
If New Hampshire attempted to oppose a tax on that, then there would be a question as to which state takes priority. Now, there's no indication in the record that Delta Dental of Massachusetts is filing in New Hampshire, so we're not aware.
But when we're referring to what the legislative intent was, is there
Correct.
any provision in the legislation for that?
There is not. There is not, Your Honor. The assumption from the legislation is that employers, any policyholder, whether an individual policyholder or a group policyholder like an employer who is a resident in Massachusetts, would be responsible for the assessment. The insurer is responsible for the assessment.
And if you were right, would one expect the legislature to have addressed the possibility of non-residents being taxed in this regard, where other states may be taxing them?
It is not a problem that we are aware has arisen, Your Honor, and in the context of other premium excises, there is a proviso, we've referred to this in the brief in Chapter 63, Sections 20 and 22, where if an insurer normally, in Massachusetts, normally has to pay tax on out-of-state risks, but if they actually pay a tax on those premiums to a different taxing jurisdiction, then they're allowed to deduct it, essentially. They don't have to pay it. So we would not expect, we're certainly not seeking any double taxation. And it's clear from this court's case law that double taxation is not permitted in these situations.
Now, Section 11A provides that the organization shall, quote, annually pay an assessment equal to 2 2/2800% of the gross premiums received in the preceding calendar year for coverage of covered persons residing in this Commonwealth. Coverage of covered persons, coverage of the employers residing in the Commonwealth, that's your, the legislature, you think, used that term to refer to the employers, the coverage of the employers who reside in the Commonwealth? Isn't that sort of a strange way to refer to employers?
We think it's not just employers. We think it refers to the policyholder. Again, the defined
Okay.
term in covered person is policyholder, which may in some cases be an individual, but may in some cases be an employer. And so I think to Your Honor's question, do we talk about coverage of an employer? I think that's what you're asking. And I think in sort of a common sense parlance, we would say if an employer has an agreement with Delta Dental whereby all of its employees may obtain coverage from Delta Dental, then it's not an unreasonable use of language to say that that employer is covered by Delta Dental, even though what we actually mean, of course, in the technical sense, is that the individual employees may obtain insurance coverage through their employer from Delta Dental. But I would
What about the use of covered persons in the 911 type statutes and the emergency medicine statutes? Where it talks about, because obviously corporations and companies don't call 911 or go to the emergency department. People do.
Correct. Absolutely, Your Honor. And so this comes back to the point that covered person is a very broad definition, and it has two parts. And what you're talking about there is the second part of the definition, which undisputedly refers to all of those individuals who are entitled to health care benefits.
So basically, you're saying that covered person changes its meaning depending on where it is in the statute.
That is correct, Your Honor. That is correct. It is, again, it is a broad term. And this is not unusual in the general laws. I mean, person, generally, Chapter 4, Section 7 is defined to encompass both natural persons and corporate entities, and it has been used in precisely that way in a number of statutes, including some health insurance statutes. And just to give you one example, Chapter 176G, Section 1, defines person broadly to encompass both natural and artificial persons. And then within Section 1 itself, it talks, there are some definitions in there. For example, the definition of a group health maintenance contract that uses the word person to refer to individuals. There are other definitions, such as the definition of affiliate, where a person is used in the corporate sense. And it doesn't, the particular definition doesn't tell you which one you're using. You sort of have to divine it from the statutory context. But that's the situation here as well. With respect to Section 3, absolutely, it is talking about individual insureds who may require emergency services.
So how does this work? Let's assume we have Microsoft, headquartered in Seattle, but has an office in Boston. They have dental insurance. Is the policyholder Microsoft? Or is the policyholder the Boston office of Microsoft? And where does the policyholder then reside? Reside in Seattle or reside in Boston?
So that would be, first of all, that is the particular definition of residence as applied to employers is not a question that's presented in the case. Neither side has briefed or argued
Not
it.
to understand.
Right.
Well, no, I don't understand. Because we're trying to figure out what the legislature meant.
Right.
So the question I ask goes to the issue of what the legislature meant when it used those terms.
So corporate residence is not a concept that is foreign to this court. It has used it in, for example, the Mount Auburn Cemetery case. In the City of Malden case, has referred specifically to the residence of a corporation as where its chief corporate activities are conducted. That seems to line up with the agreed facts in this case, where it is agreed that all of the employer policyholders are employer groups that are headquartered here in Massachusetts.
So is this a be careful what you wish for case? I mean, if you're right, then does that mean that Microsoft doesn't need, or Amazon, or any entity which is headquartered or domiciled in a different state but has a substantial presence in Massachusetts has no obligation to pay excise tax because it's not a resident of Massachusetts?
Well, I think the question would be in every individual case, is the corporation a resident of Massachusetts? That was a similar question was addressed by this court in Bank of America when the court considered the meaning of inhabitant, which even though the statute appears to restrict it to natural persons, the court expanded it in that case to encompass the bank, and then looked to sort of traditional factors of how to identify corporate residence in the course of deciding whether or not it happened.
But if you're right, this if you win, this could cost the state millions of dollars, because it would mean that arguably every corporate non-resident would have no obligation to pay excise taxes with regard to dental insurance for its employees who are working in Massachusetts.
Well, it's the insurers, of course, who pay the tax, not the corporations. And so the question would be, is the insurer...
The focus is the policyholder, and the policyholder would be the entity, correct? Would be the
Correct,
employer.
that's correct, that's correct. And
So, are you sure you want us to decide that if the employer does not reside in Massachusetts, that the employer is Microsoft or Amazon or some other entity which may have a substantial Massachusetts presence that has no obligation to pay excise taxes?
The insurer has no obligation to pay, you mean?
Yeah.
That is the commissioner's position in this case, Your Honor, that we expect that insurers will pay the excise tax based on premiums received from policyholders, whether they be corporate or individual policyholders who are resident in Massachusetts. And what that phrase means, of course, awaits further development. It has not been presented in the case.
All right, thank you.
Thank you.
Mr. Ryan, good morning.
Good morning. May it please the court. My name is Daniel Ryan, and I represent Dental Service of Massachusetts in this matter. There's only one interpretation of the words covered person in this case in Section 11 that is consistent with the plain language of the statute. And it's probably worth repeating what the statute actually says in Section 11. The assessment is imposed on the premiums received for the coverage of covered persons who reside in this Commonwealth. The Appellate Tax Board correctly held that that language means the premiums received for the dental insurance coverage of employees and their family members that live in Massachusetts. Now, this answer makes sense because the premiums at issue here insured the employees and their family members. The premiums at issue covered the employees and their family members. The employees and their family members were the covered persons here. And this interpretation is also consistent with the use of covered person throughout 176I. In every occasion, in almost every occasion that covered person is used within 176I, it's clearly referring to natural persons, not just in the context of individuals using emergency services or dialing 911, but also in Section 2, which requires an insurance company that wants to operate a PPA to file a report to the Division of Insurance listing the healthcare services and other benefits to which covered person would be entitled. The covered person there, of course, is the individual who's receiving the healthcare services.
What do we do with the term policyholder in Section 1?
Well, policyholder, I think the better read of the statute is covered person is a policyholder or other person on whose behalf the insurance company is required to pay for or provide healthcare services. Policyholder there is also an individual or an employee or family member, as the Appellate Tax Board held. What the Appellate Tax Board said correctly was that it's policyholder or other person to include both the employee and also members of the family dependents. It also is included to take into account individuals who buy insurance outside of the group insurance context within non-group settings when the policyholder, the individual, would contract directly with an insurance company in order to obtain coverage for themselves and their family members. In Section 176M, in fact, confirms this because 176M outlines non-group health insurance requirements and specifically includes preferred provider arrangements. Now, it doesn't make any sense here to treat employers as the covered persons in Section 11 because the covered persons are not actually insured. They are not covered. They are not covered persons. There's no dispute here that the employer, and according to footnote 5 in the Commissioner's brief, the employer is neither the insurer nor the insured. So interpreting covered person as the employer would mean we're in a situation where the employer is the covered person but is not actually insured. And that certainly cannot have been the intent of the legislature here. Using covered person to refer to individuals and their dependents only works consistently throughout the statute. You don't get into any of the difficulties that you have where you have to determine when sometimes the legislature was referring to employers and sometimes they were referring to employees depending on how you read the statute. Reading the statute consistently as referring to individuals works throughout the entire statutory scheme. And in fact, the legislature uses covered person elsewhere. In each occasion when they use covered person in other statutes, they're clearly referring to individuals. For example, 176G, Section 11A refers to a covered person's ability to receive dental services. 176U, Section 1 refers to a covered person receiving long-term care insurance. 176J, Section 3A2 refers to a covered person's age when their coverage begins. 175, Section 110K differentiates between covered persons and employers. Another phrase that's included within Section 11 really shows that the legislature was intending to refer to individuals when they use covered person in that section, and that's residing in this Commonwealth. On almost every occasion in which the legislature uses the phrase residing in this Commonwealth, they are referring to individuals. We spent much time in our brief outlining the number of different times the legislature has used that phrase to refer to individuals. On the other hand, very few times does the legislature use the phrase residing in this Commonwealth when they're referring to non-humans. So I think the use of that language within Section 11 makes it clear that the legislature in Section 11 was referring to individuals. And again, this is not an odd interpretation or anything like that. At trial, the department's witness testified that he agreed with Delta Dental's interpretation of the statute. He testified that that a covered person is an individual. He said it's right there in the statute and it's in the instructions as well. He's the person that initially reviewed the return. He's the person who originally at the administrative level signed off on Delta Dental's refund request. So I think that there's a large host of things you can point to show that a covered person is an individual within the statutory scheme in 176I. There is very little you can point to show that a covered person refers to employers. The legislature would not have enacted a statute without any guidance whatsoever as to when they mean individuals and when they need employers. They enacted a statute in which it's a health insurance statute. It's going towards the coverage of individuals. And so it's natural to read covered persons as a person covered by insurance, the individual that is insured. And just one note on 176I, Section 1. That indicates that the covered person is the policyholder or other person on whose behalf the insurance company is required to pay for or provide health care services. The on behalf of makes it clear that the legislature was referring to the individual, and that's because only an individual is able to have health care services provided to them, and only an individual is required to have their health care services paid for. So that definition in and of itself indicates that the covered person is an individual.
But if an employer's employees are not being properly covered, the employer has the power to complain, does it not?
They do, and the employee has the power to complain as well. There is a process within the contract that is in the record that is a contract between, it's identified as a contract between the individual employer, the employee rather, and the Delta Dental that they can file a grievance for coverage, and then ultimately they can go to the Division of Insurance and ultimately sue in Superior Court if they're not satisfied at the result. So they do have the ability to complain as well. If the court has no other questions, then that's all I have for you.
All right, thank you.
Thank you very much.